Dear friends, colleagues, and arbitration enthusiasts, good morning, afternoon, or evening, depending on where you are on the globe. Welcome to the Turkish Arbitration Academy's webinar channel. For those of you who do not know us already, the Turkish Arbitration Academy is an initiative that has the aim of developing arbitration in Turkey by conducting qualified scientific research in the field of arbitration and dispute resolution more generally, with the engagement of established practitioners and researchers, principally through conducting various types of training, organizing events, webinars, national and international symposiums, conferences, and workshops, with the ultimate desire of enhancing national and international cooperation in the field. As most of you already know by now, we have currently dedicated the series to the examination of arbitration laws of major arbitral jurisdictions. Hong Kong is undeniably one such jurisdiction. As such, today we will be conducting a deep dive into Hong Kong's laws and practices relating to international arbitration, with a focus on the year past, that is 2023. We are fortunate to be joined today by Pryderi Diebschlag of Clyde Co Hong Kong. Pryderi is counsel in the dispute resolution group at Clyde Co. He has a broad practice covering international arbitration and litigation, but focuses on commercial disputes arising out of joint ventures and the energy and commodities sector. He is a fellow of the Chartered Institute of Arbitrators, a co-chair of HK45, which is the young practitioners arm of HKIAC, so the Hong Kong International Arbitration Centre. He is an executive committee member of the Hong Kong Maritime Law Association and sits on the policy subcommittee for the campaign for greener arbitration. I know him from his role as an editorial assistant for one of Asia's largest and longest running legal journals, the Asia Dispute Review. While he started his career in London, he has been in Hong Kong for almost 10 years, so should be well placed to talk us through the latest developments. I wish to remind the audience that we will accept questions at the end of the presentation, so please do populate our chat box with questions during the delivery and once it has ended, which I will raise at the end along with some of my own. Finally, a reminder that this webinar will be recorded and made available on YouTube in case you need to duck out and re-watch later or would like to recommend that others watch it. Without further ado, I will pass the microphone on to Pryderi to journey us through Hong Kong's recent arbitration laws and cases. Pryderi, the virtual floor is yours.
Thank you very much. Okie dokie. Well, firstly, good afternoon, good morning, good evening, depending on where everybody is. Thank you for the introduction. So I propose to speak very briefly about Hong Kong in general first, so that we all understand the jurisdiction in a structural sense before we look at a few key cases from last year. So if we could have the next slide, please. As I say, this is the roadmap. We'll go through firstly an overview and then a few cases before we turn to the Q&A. Next slide. So firstly, it's quite important to understand Hong Kong's legal structure. Now, many of us will have heard of the one country, two systems concept. Hong Kong is very much part of China. That's the one country part. But unlike mainland China, which is a civil law jurisdiction, Hong Kong is a common law jurisdiction, and that's the two systems that it coexists. So now that two systems model was scheduled originally to last until 2047, but Xi Jinping recently confirmed that actually the common law system in Hong Kong will continue after 2047, and that gives us a wonderful amount of long-term certainty that what we know now will continue. Now, the huge benefit that we have as a common law jurisdiction is that the Hong Kong courts are bound by precedent, and that makes outcomes in the supervisory courts relatively predictable. And the courts here also pay very close attention to the development of the common law in other Commonwealth jurisdictions. So we have the benefit not only of our own courts jurisprudence, but also that of the UK, Australia, Singapore, Canada. And in the Court of First Instance, we have a dedicated judge who sits in charge of arbitration-related cases. That's Mimi Chan. She was an arbitration solicitor, a partner at two major law firms in Hong Kong for about 25 4 years, I think, before she became a judge. So she fully understands what it is that we do. Now, above that, you have the Court of Appeal and then the Court of Final Appeal. And our Court of Final Appeal is somewhat unique because it is comprised of local judges, but also foreign judges. There's no nationality requirement in Hong Kong for the majority of judges. And these foreign judges include names that you may well be familiar with. For Brits amongst the audience, Lord Hoffman, Lord Neuberger, Lord Sumption, they sit on our Court of Final Appeal. For Canadians, we have Madam Justice Beverley McLaughlin. For Australians, we have Mr. Justice French, Mr. Justice Keane, and Justice Gummow. So we have major names from around the Commonwealth. Another aspect of the two systems is that Hong Kong has its own arbitration law that is entirely separate from the arbitration law that is enacted on the mainland. And we are essentially an UNCITRAL model law jurisdiction with some minor tweaks. Now, I mention all of this because it's background that's really quite important if you're considering arbitrating here, because you need to have faith in the supervisory courts. You need to understand the structure in which our judges operate. And the Hong Kong courts have a very long record of neutrality and being very strongly supportive of the arbitration process. So this is where we turn to some of last year's cases that will give us some examples of how this works in reality. So the first one on the slide here is C&D. Now, this case asked essentially whether a failure to comply with stepped dispute resolution with a stepped dispute resolution clause, or you can call it a tiered dispute resolution clause, was to be treated as a potential jurisdictional defect on the part of the tribunal. And before this case, the classic case was Emirates Trading Agency. I've put, for most of the cases that I talk about today, they're on the slide, so you can see them. So I won't give you the full reference. But Emirates Trading was the classic case, and the case in that, the clause in that case was essentially one which said the parties will first seek to resolve their disputes through friendly discussion, and that required 4 weeks of friendly discussion. And because the negotiation period there was clearly defined, and it was clear that discussions were to take place, the court felt that the public interest would be served by requiring the parties to give effect to the parties' bargain. So in 2015, there was a risk that under English law, awards could be set aside for a failure to comply with the preconditions. It was a jurisdictional issue. And around the same time, a similar decision, for example, was reached in Singapore. That's the International Research Court case on the slide. But that all began to change, I think, in about 2018 with PAO Tatneft in Ukraine. Now, in that case, a distinction was drawn between situations where the tribunal had jurisdiction, but the claim was inadmissible, and situations where the tribunal actually had no jurisdiction. And this idea had developed in investment treaty arbitration and was then being brought across into the commercial arbitration sphere, which sort of finessed what was meant by a lack of jurisdiction. And that idea gained traction over the years since 2018, and it's been applied in several cases. There's cases in Singapore, BBA and BAZ, where time bar was held to be an admissibility issue, not a jurisdictional issue. There's a case in the UK, Republic of Sierra Leone and SL Mining. But until C&D, the case that we're talking about today, we had no authority on this point in Hong Kong. So in C&D, the facts are actually quite simple. It was a contractual dispute between a Hong Kong company and a Thai company representing or regarding the operation of a jointly owned broadcasting satellite. And the contract was governed by Hong Kong law, and it required the parties to, the classic, to resolve disputes through good faith negotiations. Everybody has seen clauses of that nature. Now, only if a dispute couldn't be resolved amicably within 60 days of the request for negotiation could the dispute then be referred to arbitration in Hong Kong. Now, D commenced arbitration, and C objected on the basis that that procedure, the 60 days of negotiations, hadn't been complied with. The tribunal determined the issue, they disagreed, and they found against C. They found C liable for breach of contract. C then applied to the Hong Kong courts, to the Court of First Instance, to set aside on the basis that the pre-arbitration requirement had not been complied with. And the crux of the matter was really whether the court had the power to revisit the tribunal's decision, because the tribunal had been asked the question and they had determined it. And under section 3.2 of our arbitration ordinance, it's very clear the court should only interfere in the arbitration of a dispute as expressly provided for in this ordinance. And so what does the ordinance say on this point? Well, it recognizes competence. Section 34 of the arbitration ordinance provides that the arbitral tribunal has authority to rule on its own jurisdiction. There is an appeal process, though. If the tribunal rules that it does have jurisdiction, as it did in this case, Section 34 allows the party to appeal that decision to the High Court. And then the High Court looks at it entirely de novo. And that is a final decision, an unappealable decision from the High Court. So I hope it's clear that the court can only reopen the discussion if the tribunal has ruled on its jurisdiction. And the question then is really, was this a question of jurisdiction, or was it a question of admissibility? Was it that other category under PIO and TATNAT? And C lost in the High Court, and in the Court of Appeal, and in the Court of Final Appeal. Each court found that C's objections went to admissibility, not to jurisdiction. So the court couldn't intervene. So I suppose the real takeaway and the real point that we have to focus on here is, how do we tell the difference between an issue of admissibility and an issue of jurisdiction? And I've put the Chief Justice's version of this on the slide, where Chief Justice Chung suggested that, in short, objections to the tribunal as opposed to the claim itself are, generally speaking, objections which go to jurisdiction. Now, that is very helpful. I personally quite like Jan Paulsen's version, which suggests that we need to simply ask ourselves whether the nub of the challenge relates to the forum itself. Are you challenging arbitration? Or are you challenging the timing? Are you challenging some other aspect? If you're challenging arbitration as a forum itself, that is jurisdictional. Now, the Hong Kong Court of Final Appeal then went one stage further and said that actually there should be a general presumption that a failure to comply with contractual preconditions to arbitration goes to admissibility, not to jurisdiction. But that is only a tool to assist with construction. It's only a general presumption. So if you want to, and I admit that it's difficult to think of a situation where you would want to, but if you want to, you can draft with very clear and unequivocal language an arbitration clause that would say that if you do not comply with the tiered arbitration clause, if you don't comply with the steps, that is a jurisdictional issue. So you could do that. You could say that if you don't negotiate, actually the tribunal is deprived of jurisdiction. But as I say, it's quite difficult. If you are already minded towards resolving your disputes through arbitration, there are probably good reasons for why you would do so, the New York Convention or privacy or speed. And it's quite difficult to imagine under what circumstances a failure to comply with those preconditions would undermine all of those other reasons and push you back to the courts. But anyway, it's entirely possible. That is a one-way street, though. You can make something which is admissible up into a jurisdictional issue if with careful drafting. What you cannot do, of course, is take a jurisdictional problem and reduce it to an admissibility issue. That's not possible. So next we will talk about two cases, G and X and G and N. Now, both of these touch on the issue of remitting awards back to the tribunal. And I've I want to talk about these two today because they're quite a good example of how the Hong Kong courts try very hard to sustain an arbitration award rather than have them set aside. So first, if we look at G and X, in this case, it was a CTAC arbitration, and G claimed that he'd been induced by fraud to sell assets in an online music company below their market value. And the award was ultimately handed down for about 90 million US dollars. And X sought to set aside on the mainland of China. Now, the reason given for that set-aside application was that what the tribunal had done was actually determine the quantum entirely on its own using evidence that it had collected. And it had collected that without the parties' involvement, had not sought their input on it. And the mainland courts agreed that that's not permissible. So they directed that the quantum should be re-arbitrated by an entirely new tribunal. And the new tribunal determined to make no adjustments to the award, noted that the original award had not been set aside and it still had full legal effect. So on the mainland, that set aside failed, and essentially you had a remission to the tribunal, to a new tribunal to do it again. When it came to enforcement, X again tried to challenge enforcement in Hong Kong, and the Hong Kong courts were not impressed by that. The alleged defect had already been addressed, and to quote, there was absolutely no ground to refuse enforcement in Hong Kong. An award remains valid even if it has been remitted back to the tribunal for further consideration. Remission is not a separate new arbitration. It is an opportunity to correct defects or potential defects. And there's also a very helpful reminder. It's an obiter comment, but it's a helpful reminder in this case that in Hong Kong, it is entirely permissible to seek enforcement of an award that has been set aside at the seat, because set aside and enforcement are separate. They're separate concepts. It's very rare that that's happened, but it's entirely possible here. Next, G and N, again, a remission case. This one, the case concerned a private placement of shares, and a BVI court had found that that placement was illegal and void. Now, G commenced arbitration seeking restitution of the funds that it had paid for this failed placement. And in the first award, the arbitrator applied a case which some of you may know on illegality, Tinsley and Milligan, English case, and considered that the placement was illegal and the personal proprietary claims both failed, for illegality on one hand and for unclean hands and equity on the other. The problem was that shortly before the award was handed down, Hong Kong's Court of Appeal decided that it preferred the more modern test of illegality set down by the courts in England in Patel and Mirza. So the law in Hong Kong had changed on illegality just before the award was handed down, and G applied to set aside. Now, under Hong Kong law, you can't appeal an arbitral award for errors of law. Now, that is possible in the UK. It's not possible in Hong Kong. We have it as an option, but it's opt-in only. So in this case, G was playing a very fine line and sought to set aside on grounds of public policy and scope and procedure, sort of a jurisdictional challenge, and was very clear that what they were not trying to do was challenge for error of law. And the court considered a Privy Council case called Betamax and State Trading, which I haven't put on the slide, I apologize, and found that while there can be no review of the arbitrator's findings of law and fact, what the court can do is consider whether there is a conflict between the award and public policy. And it should do that on the basis of the law at the current date. So the public policy question would be considered against the backdrop of Patel and Mirza, not against the backdrop of Tinsley and Milligan. So on that basis, the court said that actually G may have a good arguable case for setting aside, but instead of doing so, the judge ordered that the setting aside proceedings should be suspended for 3 months and the matter remitted back to the arbitrator so that he could consider whether Patellamerzo would actually affect the outcome and he could do something about it. On the second argument, the jurisdictional challenge that was raised, the court found that actually in the arbitration, G hadn't raised its jurisdictional challenge in the defense to a counterclaim. But what was interesting was it had raised a challenge to admissibility during the arbitration, and in so doing, it had expressly stated that it was not arguing a jurisdictional challenge. And as a result, it was stopped from raising the jurisdictional challenge afterwards. And I'd suggest that this is quite a useful case because it neatly shows two aspects of the court's pro-arbitration stance in Hong Kong. Firstly, the court won't set aside an award if the defect can be corrected. And secondly, that the court really does expect the parties to comply quite strictly with timelines. There is a set timeline for raising jurisdictional challenges. What you can't do is sit and wait to find out the outcome of your arbitration before you raise a jurisdictional challenge. Now, there is a wrinkle here, which is that leave to appeal has been granted in GNN. So we'll have to see how that plays out this year, and perhaps I'll tell you about that in a few months. So the next case to talk about is C and G and another. Now I've put a fairly long quote on the slide, and I don't suppose to read it. But I mention this case because this seminar is meant to be about the law and practice element of arbitration in Hong Kong. And this case is important because it shows the court issuing a very clear signal to the legal market that legal counsel have obligations to the court and must not massage, to quote the judge, a case to try to find something halfway arguable for a set-aside application. In this case, it was essentially the applicant threw everything, threw the kitchen sink at it to try to find something that would stick for a set-aside application. And the judge was pretty unimpressed, and indemnity costs were ordered, and given the legal teams, that will have been a very, very significant sum, I'm sure. You can read that slide in your own time, but it's pretty painful reading if you were the applicant's legal team. Next, winding up. Now this requires a little bit of explanation. There's a bit of background to go into because it's quite an interesting area of law. It's the interaction between arbitration and insolvency. And as you may know, under Hong Kong's insolvency law, a creditor can petition to wind up a company on the basis that it's unable to pay its debts. Now that shouldn't surprise anybody. I'm sure that's the case in many jurisdictions. The company can oppose this, and the traditional argument is the company will oppose this if it can show a bona fide defense to the debt on substantial grounds. Now, the debate here really turns on what happens if the debt is disputed and the debt arises out of a contract that is subject to an arbitration agreement. Do you have to go to arbitration and get an award in that arbitration before you can then utilize the insolvency regime? Or does the insolvency regime override the arbitration agreement? Now, we can begin with section 20 of the arbitration ordinance, and that is that the court is required to refer parties to arbitration if a matter brought to the courts is the subject of an arbitration agreement. But insolvency petitions don't fall within section 20 of the arbitration ordinance here, because insolvency petitions are a different thing. They are a class remedy that's available to all creditors, and they don't involve the enforcement of a particular creditor's contractual rights against the debtor. It's a statutory basis. And as a winding up petition doesn't actually adjudicate the dispute between the parties, even if it's granted, it's not a decision on the merits. So it doesn't fall foul of section 20 of the arbitration ordinance, which means there is no mandatory stay to arbitration. So you end up with this debate. Should the existence of an arbitration agreement result in the court proceeding with the petition to wind up? Should it result in the court staying the petition or entirely dismissing the winding up petition? Now, in different common law jurisdictions, the courts have taken different approaches to this question. And these three approaches have risen to the top, the ones that I've put on the slide. The traditional approach, as I mentioned, that the petition should be stayed or dismissed if there is a bona fide dispute in relation to the debt on substantial grounds. That should be regarded as the baseline, the historical baseline in Hong Kong. Now, there are two alternatives. In the UK, there's a case called Salford Estates. And this case essentially says that the petition should be stayed or dismissed if there is a prima facie dispute on the debt, and it's subject to an arbitration agreement. And so this one essentially favours the debtor. If the debtor can show that there is an arbitration agreement, it has essentially got a defence. It can say, no, don't wind me up. We need to resolve this in arbitration first. There's then a third version, which we'll talk about in a moment, but it's Lasmos, which is a Hong Kong case from 2018. And this essentially says it's a bit of a middle ground. The petition should be generally dismissed if there's an arbitration agreement, provided the debtor has actually taken the steps required under the arbitration clause. So essentially, it's not good enough to just hold the arbitration agreement up to the judge. You actually have to show that you are proceeding with it. Now, in Salford, the rationale behind that position was that it would be anomalous for the company's court to conduct a sort of summary judgment type analysis of liability for a disputed debt when the creditor has already agreed that disputes should be referred to arbitration. So that the company's court doesn't have any place to be looking at the debt when there's already a jurisdictional agreement. And it was felt that if primacy wasn't given to that arbitration agreement, it would encourage parties as a standard tactic to bypass an arbitration agreement and just present a winding up petition. You present your statutory demand and then you proceed with the petition. And that approach, as I mentioned, it places insolvent debtors who are party to an arbitration agreement in a vastly better position by comparison with other insolvent debtors, because it allows them to fend off insolvency proceedings and require an arbitration to take place first. Now, the English courts and the Singapore courts have followed Salford Estates in many cases. We didn't in Hong Kong. We went with Lasmos. And essentially, that case sets down these three requirements. The debtor disputes the petitioning debt. The contract under which the debt arises contains an arbitration clause. That arbitration clause covers the dispute, giving rise to the debt. And then, as I mentioned, the third step is key. The debtor actually takes steps required under the arbitration clause to commence the contractually mandated dispute resolution process. So Lasmos does buy into Salford, but it requires that the debtor is willing to put its money where its mouth is. If you say it is disputed, you say there is an arbitration clause to show us that you're actually going to arbitrate. Now, the problem is in Hong Kong that Lasmos was only a decision of the court of first instance, so its precedential value is pretty limited. And the issue then came before the Court of Appeal a year later in 2019 in a case called But Ka Chon. That's on the slide as well. And there the Court of Appeal did agree that the traditional approach, which purely looks at whether there's a bona fide dispute, the traditional approach gives insufficient weight to the existence of an arbitration agreement. And they recognized that if they ignore an arbitration agreement, that might encourage parties to bypass their agreement to arbitrate. But the Court of Appeal also felt that the Lasmos approach represents a substantial curtailment of a creditor's statutory right to issue a stat demand and issue a winding up petition, because it requires the courts to dismiss the petition in favor of arbitration unless there are exceptional circumstances. So they weren't pleased with this sort of fettering of the discretion. Now, the problem with But Ka Chon is that whilst the Court of Appeal clearly had some concerns, all of its comments were obiter. So they weren't binding. They didn't overrule Lasmos, and they didn't make a clear determination as to whether Salford should apply or the traditional approach should apply. Now, at the same time, Singapore was having a similar debate. In 2018, there's a case where they followed the traditional approach. I think in 2019, they followed Salford. 2020, they adopted a bit of a tweaked version of Salford. And we can discuss that perhaps another day, or you can reach out to me if you're interested in those cases. But focusing on Hong Kong for the moment, we move forward to 2021, and there's then a case again in the Court of First Instance, so not bound by Lasmos because it's of the same tier level of court, where Madam Justice Linda Chan applied the traditional approach. Did not go with Salford, did not go with Lasmos, went with the traditional approach. And that then brings us more or less up to date to 2023 and the Court of Final Appeals decision in the title case for this slide, which is Re Gai Kwok Hung Lam. And this went all the way to the Court of Final Appeal, to our apex court. In Gai Lam, a creditor presented a winding up petition that was based on a loan agreement which contained an exclusive jurisdiction clause. And that clause stated that New York courts were to have exclusive jurisdiction over all disputes arising out of the agreement. And the debtor opposed the petition on the grounds that the New York court hadn't determined liability yet, which is pretty similar to the Salford Estates argument, right? The arbitration hasn't determined the debt yet, so you can't wind me up. In the Court of First Instance, that failed. The judge was Linda Chan, the same judge that I mentioned a moment ago who applied the traditional approach. And in Gai Lam, in the Court of First Instance, she did the same thing. She applied the traditional approach. But on appeal, the Court of Appeal dismissed the winding up petition and applied Salford Estates. And so they did it on the basis that a winding up petition is a class remedy, but it doesn't follow that because it's a class remedy, the insolvency regime trumps the party's agreed dispute resolution mechanism. And there are very strong policy reasons to require parties to abide by their contract. Merely saying that an exclusive jurisdiction clause is only one factor to be considered doesn't really give commercial parties the certainty that they need when they're contracting. So that was the Court of Appeal. And then we went up to the Court of Final Appeal, 2023, and they agreed. They agreed with the Court of Appeal. They said that the public policy considerations which commonly favour the creditor under the traditional approach carry much less weight when the petition is brought by only one creditor. So under Gai Lam, where there is an exclusive jurisdiction clause, a winding up petition should not be allowed to proceed until the dispute has been determined by the courts of the other forum, the exclusive jurisdiction forum, unless there are strong reasons to the contrary. So, for example, if the dispute, frankly, is frivolous, it amounts to abuse of process, or there is evidence that there is a much wider community of creditors who are at risk. And this is the point where if a petition is brought by one creditor and that one creditor has an arbitration agreement, then you would go down the route of following the arbitration agreement. Of course, if it's brought by many creditors, or you know there is a large pool of creditors, that is a slightly different situation. Then you may fall into the strong reasons to the contrary. Now, that judgment of the Court of Final Appeal, was in early May 2023, and it was promptly tested 2 or 3 weeks later in an arbitration context. Because remember, Gai Lam is actually about exclusive jurisdiction. It's not about arbitration. And that was tested in a case called Re-Simplicity and Vogue Retailing. And I've put that case on the slide there. That was tested in arbitration. Now, despite the parallels between an exclusive jurisdiction clause, which removes a case from the jurisdiction of the Hong Kong courts, and an arbitration clause, which fundamentally does the same thing, it removes the case from the jurisdiction of the Hong Kong courts. Linda Chan robustly held that Gai Lam only applies to exclusive jurisdiction clauses. Now, for arbitration, her reasoning there was that for arbitration cases, the courts should not fetter their discretion by applying a mechanistic approach that was suggested by Lasmos or by Salford Estates. And that favors the arbitration clause and therefore the debtor. Rather, what you should do is you should consider whether the alleged defence can readily be shown to be without merit. And if yes, then there's no need to refer the matter to arbitration. Because if there's no merit in the defence, then why force the parties to go down that route? And so she granted the winding up order in simplicity. That was sort of down the traditional route again. Now, 2 months later in August, or 3 months later, in August 2023, Harris, the same judge from Lasmos, he seized upon the Gai Lam case and said that it definitely applied to arbitration by analogy. So you had a bit of a mismatch between Justice Harris applying Lasmos and feeling that Gai Lam was supportive of Lasmos, and you had Linda Chan, Justice Chan, saying, actually, no, Gai Lam only applies to exclusive jurisdiction clauses, and for arbitration, you must fall back on the traditional approach. Both cases appealed, and if I'm abiding by the rules of today, I should stop talking there and leave it on a cliffhanger, but I won't do that. I will tell you what the outcome is, because it feels a bit rude to leave you in limbo. On appeal, Simplicity came back and said at the Court of Appeal, Gai Lam does apply to arbitrations. And not only does Gai Lam apply to arbitration, but it would be sensible, quote, sensible for the court to require a debtor who seeks to rely on an arbitration clause to show that they have taken steps to actually initiate that process. So actually, we now have Court of Appeal authority that supports Lasmos. So that's where we are now. And you've got the Gai Lam decision there from the Court of Final Appeal, which neatly summarizes that issue. So moving on, we've talked a lot about how supportive Hong Kong is of arbitration. And I thought it would be worthwhile showing you what the limits are. How far can you push it before Hong Kong says, no, enough is enough? And Song Li Hua is quite a good case for this. There are two aspects to it, hence why there are two case references on the slide. Now, in this case, an award had been rendered in China under the auspices of the Chengdu Arbitration Commission. It's a Chinese arbitration institution. And a set-aside challenge was launched in the local courts, and that failed on the mainland. Now, because it failed on the mainland, enforcement was challenged in Hong Kong. But here, the applicant faced a pretty major evidential difficulty. The hearing had been conducted by video, and they didn't have the video. The challenge was largely based on the fact that the arbitrator didn't give the hearing his full attention. And so without this evidence, they felt inherently weak, and the court was first asked in the first hearing for an order that would force the arbitrator to give evidence as to where he was, what he was doing, who was around him, how he was listening to the submissions. And this raised an interesting question of immunity. Can an arbitrator be compelled to give evidence to the court in support of a challenge to his own award? And the court considered English and Canadian authorities and held that there is a need to protect arbitrators' independence and to protect their judgment from threats of lawsuits. So arbitrators should be entitled to the same immunity that judges get in respect of their decision-making process, of course, absent bad faith or fraud. So no, they can't be compelled to give evidence against themselves. Well, after the application to compel the arbitrator to give evidence failed, Lee challenged enforcement anyway. And by this point, whilst the Arbitration Commission on the mainland had refused to provide a copy of the video, they had allowed it to be inspected. So it had been viewed, and extracts had been viewed. And it turns out that actually the conduct complained about by Lee was that over the course of a 2-hour hearing, the arbitrator had barely been stationary for more than a minute and was seen walking from room to room. At one point, the arbitrator got into a car, drove around, caught a train, lost signal on the mobile phone, was seen staring into the distance. And all of this was done while listening to the proceedings, which are obviously confidential, on speakerphone in public. This pretty egregious behavior. And Mimi Chan referred to a case called Stanbury and Data Pulse, in which a member of an employment tribunal had fallen asleep during a hearing. And Peter Gibson quoted Lord Steyn in the House of Lords in a case, it's on the slide, Lowell and Northern Spirit, where he said, what the public was content to accept years ago is not necessarily acceptable in the world today. The indispensable requirement of public confidence in the administration of justice requires higher standards today than was the case even a decade or two ago. Now, in answer to that, Song argued that Lee had waived his right to complain because he didn't raise an objection during the hearing. And of course, this was conducted on video, so it was known what was happening at the time. And of course, the tribunal has the right to determine the procedure. The tribunal did allow the arbitrator to dial in remotely. But Mimi Chan had very little time for this, Mimi Chan being the judge in charge of our arbitration list. And she said that even if they had failed to raise an objection during that hearing, the ground of public policy can be raised and relied upon by the court, because it appears to me that it would be contrary to public policy of Hong Kong to enforce the award. And the quotes on the slide, it would violate the most basic notions of justice in our forum and should be refused. So that gives you a little idea as to exactly how far we will tolerate things going, and for example, remit awards back to the tribunal to correct issues. We had one recently where it was remitted back to the tribunal because the tribunal had failed to deal with all of the issues presented to them, and so that was remitted back. There was a question recently whether or not awards needed to be fully reasoned or whether a skeletal reasoning was sufficient. And in that case, some reasons are sufficient. It's only if it is entirely without reasons that it's subject to be set aside. And then you see here where, frankly, if you are not paying attention as the arbitrator, justice is not being done. And so then you are at risk of having your award set aside. So that brings us quite neatly to the end of the trot through last year's cases. I hope you gained something from that. And if you've got any questions, I'd be very happy to take them.
Thank you very much, Pryderi. That was a clear, engaging, and illuminating presentation, if I can say so. I think the Song Li Hao case is a stark reminder and warning that one should not arbitrate while commuting. You would have thought that it would not have been permissible, but it seems you need a court decision to tell us that. Now moving on to questions. I have a few questions of my own, which I think I'll raise first, while we have the audience kind of populating our chat box with questions. So to get the question phase flowing, my first question is, I've heard about the recent interim measures arrangement in Hong Kong. What's the latest on that? Do you mind please elaborating on that a little bit and kind of explaining what the recent trends are?
Sure. So the interim measures arrangement made news a couple of years ago, and we continue to bang the drum because it's our unique selling point of Hong Kong arbitration. For anyone who doesn't know, it's not possible to get interim relief in China in aid of foreign-seated arbitrations, and the only exception is under Hong Kong's interim measures arrangement. and that came into force in 2019. It allows parties to Hong Kong seated arbitration. Point one, you have to be seated here, and you have to be administered by a few specific arbitration institutions: BHK, IAC, CTAC, ICC. You have to be administered by them, and that allows you then to obtain orders from the Chinese courts to preserve assets, preserve evidence, to prohibit certain conduct, and you can do that during an arbitration, and you can actually do it even before you commence arbitration. And it's incredibly powerful because what it means is that you can secure assets so that you know that actually what you are doing is not going to be in vain. The last time, I'm perhaps a month or two out of date, but the last time I looked at this, we'd had more than 100 applications for interim measures. I think the total sum in dispute was something like $3.5 billion that was trying to be frozen. And we don't know the outcome of all of those applications. But I think we know something in the region of about 70 of those applications. We know how they've turned out, and the Chinese courts have actually enforced about 95% of those applications. So you have a pretty good acceptance rate, and it's really quite valuable. In fact, it's so valuable, and to give you the sort of the difficult news is that actually well-advised Chinese parties are now turning around and saying that they would prefer not to be seated in Hong Kong sometimes, because they recognize that if they are seated in Hong Kong, that their counterparty has this ability to go after their assets very, very quickly. So there's a bit of a debate there as to whether or not this is now still a unique selling point and something that's incredibly beneficial to us, or something whether actually it's doing a bit of damage.
Yeah.
But for the time being, I think it's a real selling point if people can get a Hong Kong seat agreed and one of the institutions agreed. So just to round out that thought process for anybody who doesn't know, certainly for the time being, arbitration on the mainland must be institutional. Ad hoc arbitration is not tolerated on the mainland, which is why there is this institutional requirement under the interim measures.
Okay. I just as a side note, I think I must add that I do think Hong Kong interim measures in Hong Kong are highly effective. I recently myself applied for an emergency arbitration arbitrator award in connection with an arbitration that was seated in Hong Kong, and it does speed up the dispute resolution process when you can secure those kind of innovative and highly effective measures from the Hong Kong courts. So I will second that definitely. Now, second question that I have is, you mentioned that under Hong Kong laws, an arbitral award cannot be challenged on the basis of issues of law. So if the tribunal has erroneously applied the law, unless the parties opt in to that process. Do people ever opt in? What's your personal experience? And also, what do you advise your clients to do? Do you advise them to opt in or keep it as opt out?
Frankly, it's seen very rarely. It's entirely possible it's Schedule 2 to the arbitration ordinance. I think prior to 2017, for purely domestic arbitration, it was an automatic opt-in. But the reality is now it's only really seen in domestic construction clauses. There was a case on it last year, which I think was called something snappier because it was in a construction cases. As you'll have seen from the slides, it tends to be C and D, A and B in the Hong Kong courts, anonymize everything. I think this one was employer and contractor. Still anonymous, but it helps everybody to understand who's who. And in order to opt in, what you still need is the court to actually give you leave to appeal. So even if you've opted in, it doesn't necessarily mean that you can. You then still need to turn around to the court and show that the decision will substantially affect the rights of one of the parties, that the question had been put to the tribunal, and then that, given the findings of fact, either the decision was obviously wrong, or if it wasn't obviously wrong, then it's open to serious doubt, which is a much lower threshold. But if you're going to go down the lower threshold, then it also needs to be a matter of significant importance. And that generally means that it's a public form or a commonly used form. It's a standard term. So actually having a public hearing on this issue will benefit a wider class of people. The one time that I have gone down this route, we tried to argue that it was a common form, and they said, no, this is too niche of an issue. We're not going to go down this route. It wasn't obviously wrong.
Sure.
So the threshold's pretty high, and you need to make sure, if you're going to have a hope in hell, you need to make sure your written submissions make the error from the tribunal very, very clear. As to whether or not I recommend that parties do opt in, frankly, it's a commercial call. Some parties quite like to have the ability to continue to fight if it goes against them. But I would say, in my experience, the vast majority prefer the finality. And of course, then you can if it does go against you, you can challenge enforcement, you can challenge and set aside, but they prefer the finality of an award.
Yeah, okay, very helpful. Just a related spin-off question. Under English law, so under the Arbitration Act 96, Section 69, we have the opt-out procedure, so slightly different procedure to under Hong Kong law. The parties have a right to appeal on a point of law unless they've agreed otherwise, so they have to opt out of the procedure. And then the requirement to seek permission to appeal also is an additional hurdle. Again, very high threshold, so difficult to kind of satisfy that. One criticism, despite English law giving the default right to appeal, but with the high threshold, one criticism of that has been that has adversely impacted the development of the common law. If you're stopping case from getting to courts for the court to assess whether the law was correctly applied, then are you adversely impacting and stopping the development of the common law of the law in terms of reflecting the kind of realities and commercial world of today? What would be your thoughts on that? I mean, and what's the general perception in Hong Kong? Is the procedure of kind of requiring opt-in generally favoured by the arbitration community, or is there an even split in terms of its effectiveness and utility?
I think most, obviously I can't speak for the community as a whole, but I think most people recognize that arbitration is having a retarding effect on the development of the common law. Essentially, an enormous number of disputes that would be heard in the courts. For example, the Admiralty judges that sort of formed the backbone of the development of the common law for the last few hundred years. That a huge number of those disputes have been moved into private behind closed doors. So yes, I completely agree with that view. And it's a really difficult one, because one of the key reasons why people still go to arbitration is because you are not airing your laundry in public. You can have your disputes resolved privately. It reduces contagion risk, and people feel more able to have the disputes resolved in that forum. Now, does that mean that we need to make awards public? Certainly at investor state level, that is a thing. They are publicized, and there is a move now towards anonymizing awards, not so much in Hong Kong, frankly. What we have got recently, perhaps a year ago or 2 years ago, the HKIAC produced a anonymized case digest that you can access on their website, which tells you how they deal with procedural issues. So it gives you a little bit of an insight. For example, the HKIAC act as the appointing authority for arbitrators, and they will determine if your arbitration clause doesn't specify the number of arbitrators, they will determine the number of arbitrators for you. And so you can look through the case digest and see how they approach that issue. So that's quite a useful thing. I'm not saying that it approaches anything like the development of the common law, but it's a baby step.
Point taken. Thank you. So we have a question from the audience, which is, would the erroneous application of the laws relating to interest rate, for instance, would that be deemed as an error of law and therefore not appealable? Or would that be something else under Hong Kong laws? Assuming, I take it that assuming the substantive law is the law of Hong Kong.
I suspect, and obviously I'm not going to advise on an issue just on the fly. I suspect that would be considered an issue of quantum, and it would be considered an error of fact rather than an error of law. Interest rates, it's not law as far as I can see. If there's an error maybe in the judgment rate, that's potentially different. But again, I would still perceive that to be an error of fact. What we do have, if errors of that nature come to light, you wouldn't necessarily need to remit it back to the tribunal. You can correct things either via the slip, a slip essentially, where you can go back and correct typos, and you can also ask for an additional award to determine an issue that's been missed by the parties, or if a correction is needed. You can also get an interpretation as well.
Thank you. We've got 4 more minutes, so I'll fire my final question, and then if there are any additional questions from the audience, please do put it in our chat box. My final question is about the winding up cases. The interplay between arbitration and insolvency law is always a hotly debated issue, and often does produce knotty, difficult issues on which people can't agree. And I can see that 2 Hong Kong judges have fiercely disagreed in the public arena on that. On the Lasmos line of reasoning, I can see a difficulty where you have an arbitration clause which has a tier dispute resolution aspect to it, so you have to follow it, kind of a certain procedure, and that may not sit perfectly in line with insolvency petition filing deadlines, etc. I wonder, would the court still require the arbitration filing to be made, even though there may be an argument that the filing would be premature? What would, again, a very niche area, I'm not sure if the judgments or the case have discussed this, but would that be another kind of difficulty in connection with following the Lasmos approach, if it were to be adopted?
They actually do discuss this. So Lasmos, to be clear, does not require you to commence arbitration. Lasmos requires that you commence the contractually mandated process required by the dispute resolution clause. So, for example, if it says, exactly as you're proposing, the parties will negotiate for 2 months and then enter into mediation, and then all that is required is that you take one foot upon the first rung of the ladder, right? So you must issue your request for negotiation. Provided you are actually doing that, provided you have actually started that process, that would be good enough for Lasmos. What is not good enough is to come to court and say, I will do X, Y, Z. Now, that has been roundly criticised. However, what I would say is that the Simplicity, the recent Simplicity case, which went to the Court of Appeal 2024, there the Court of Appeal actually say, whilst we consider it very sensible, this third limb requirement under Lasmos, the idea that you must commence the process, they do say that actually there is also scope for the judge to stay proceedings so that you can do it. So they give themselves a little bit more lateral movement there at the Court of Appeal, saying that it's quite sensible to require it, but if they haven't done it, let's not treat it as fatal.
Okay,
so it's still up to discretion.
Good to clarify that point. I'm going to be cheeky 1 minute, so I'm going to fire my last question. Hopefully it'll be a short and sweet one. Arbitration, I hear, is becoming more and more popular in mainland China. What's the effect of that has been on, if any, on the preference for a Hong Kong arbitration seat. You mentioned in connection with the interim measures that Hong Kong is the reason why Chinese parties move away from Hong Kong. But generally, the popularity of arbitration in mainland China, what effect has that had on Hong Kong arbitration, for the good or for the worse?
I think it's been quite positive, to be fair. We have more cases every year being seen in Hong Kong. It's a general upward trend. So we're certainly seeing a lot of cases. I recently heard that the mainland has on average something in the region of 500,000 arbitration filings made every year, which is absolutely extraordinary to me, particularly given that they're all institutional. There's something like 270 different institutions on the mainland. So I think that interplay, and frankly, since 1997, Hong Kong is only getting closer to the mainland. And so we see that with the likes of the interim measures arrangement. So I think that will continue to strengthen Hong Kong's arbitration scene. Okay,
thanks very much. I can see we're on time. We haven't had any additional questions from the audience. So I think that brings us to an end. And it only leaves me to thank you again for taking the time in your busy schedule to join us today and lecture us on recent developments on Hong Kong arbitration law in the past. So thank you very much, Pryderi. Thanks also to our audience for bearing us with in the past hour and hang on. And it only leaves me to say thank you to all and enjoy the remainder of your day and stay well. So hopefully we will see the audience in our next webinar, which is scheduled towards the end of the month, focusing on arbitration law practices and updates of Singapore. So until then, stay well